for coming back to the Law and Crime Network. I'm Linda Kenny Bodden, and we are covering the case in Broward County, Florida, of YNW Melly, the rapper, who is accused of a double homicide, a double murder, killing his two friends in the YNW collaborative, Juvy and Sakchaser. But our own Terry Austin has been in that courtroom, and she's here with us now. Terry, I understand you have some updates about whether or not court has adjourned for the day and why.
Well, the court did adjourn for the day, partially because there are no other witnesses lined up. We saw the end of the direct and then the cross and then the redirect and the recross of the witness, Mark Moretti, who was the lead detective on this case. But then the state rested. So the judge asked if whether or not there were any witnesses lined up. And the defense is planning to call Brendan Collins, who was, if you recall, that FBI agent, but he's not available for today. So the judge allowed the jury to go, and they will come back tomorrow. So that is why the courthouse is closed for right this moment in time.
And Terry, what was the last part of the questioning that the Mark Moretti ended on? Because when we were watching the end of the cross-examination, it was pretty contentious about whether he had threatened witnesses. What did the prosecution do? What did the defense do? And how was the jury?
Well, the very last part of the witness's testimony, going back and forth, had to do with a couple of issues. We talked before about whether or not Melly used the word THAT or DAT. But beyond that, there was a list of 14 potential suspects, according to the defense, who were not thoroughly investigated. So the defense is trying to say that you really have botched this investigation. When the prosecution got back up, she tried to say, look, you followed it up with this, but it led to nowhere. They had an alibi. There were all of these various reasons why these potential suspects were not investigated. And then we did hear on defense, they were trying to establish that one of the things lead detective Mark Moretti did is he basically threatened the witnesses. He said one of the witnesses was threatened and said that he could be sent back out of the country, and that, you know, being in jails out of the country is far more difficult than being in a jail or a prison here. So that was one of the things that I think the defense was trying to establish with the testimony of Mark Moretti, and saying that he was using, you know, ways and means that he should not have been doing when he was investigating or talking to some of these witnesses, that he didn't thoroughly investigate. The part that he did do, he threatened them. So it's making it seem like it wasn't an investigation that was thorough and it wasn't done well.
And did the jury have any reaction when the defense kept using the word to the investigator that you threatened witnesses?
Well, I do think they were paying close attention, Linda, and I've said this all along. I definitely think this jury is a top-notch jury in terms of focusing, even when we've had some very difficult, some grueling, some painstaking testimony. They've been listening carefully. They turn their chairs. They look directly at the witness. I don't see them looking very often to YNW Melly. They are really focusing on what is going on in that stand, and by the attorneys as well. They look very closely at the actions of both the prosecutor and the defense. And I think sometimes when we see these defense witnesses, or rather the defense attorneys making objections, you do see the jury is listening to those objections and wondering whether or not they are hiding something, or wondering whether or not they have a right to ask those objections. And so I think it's a really smart jury. I think that they really want to hear everything that's going on, paying very, very close attention.
And speaking of reactions, did YNW Melly, Jamell Demons, did he have any reaction to, number one, the state resting, and number two, his attorneys indicating they're going to call a witness and present a case?
Well, I think he has been anticipating this. We have heard defense counsel talk about the fact that they want to bring in Brendan Collins, and they needed some help in getting him back. And so I think everyone is sort of expecting that that's going to happen, including YNW Melly, who really has been just sitting attentively. He's been writing notes today, actually. I noticed that. And he hasn't been writing notes the entire time. So I do think he is trying to assist his team in defending this case. But other than that, I would just say, he's looking at the witnesses too. It's interesting because it's one of these cases where I don't see the jury looking so much at YNW Melly. I see the jury looking at the witness, and I don't see YNW Melly looking so much at the jury. I see him looking at the witnesses too. So it seems to me that everybody wants to determine the credibility of those people who are sitting on that witness stand.
And why is the defense calling back the FBI agent? Do we know?
Well, I think one of the things they want to do is talk about this cell phone data, and this FBI agent was one of the experts as far as that's concerned. And I think they want to call him back on their own case, on their own direct case, to sort of establish that this isn't an exact science, that there are discrepancies, that either the testimony that you're going to hear about these records, it's either, not exactly accurate or not exactly precise. It's not both things at the same time. It can be accurate but not precise, and it can be precise but not accurate. That's one of the things that they said. And I know it's a minor distinction between those two words, but as far as these cell records are concerned, those are very important distinctions. And I think that's why they want to call him back up here to talk about that.
And let me ask you one final question, Terry. I know it's been a long day before I let you go, but are there any other witnesses besides the FBI agent the defense is going to call, including, have they given a hint whether YNW Melly, Jamell Demons, is going to take the stand?
Well, they talked about bringing back a civilian, and they did put on their witness list, the defense witness list, they talked about bringing back relatives. So I think we could possibly see that. I don't believe we're going to see anybody who was in one of those two cars, not one of the other 8 people, including YNW Melly. I don't think they're going to put him on. They don't need to put him on at this point, in my opinion. If they can show that the prosecution has not proven their case beyond a reasonable doubt, it's too risky. And I don't think anyone else in those cars will be put up either. I think maybe we might hear from a family member, and I don't think we're going to hear from any other government people. I think Collins is probably going to be the only one that they are bringing. The judge did talk about, perhaps after that, the charges and the closing. So I think we are in for, a conclusion this week.
Wow. Terry Austin, as usual, great reporting, telling us everything that happened in the courtroom that we haven't seen, and looking forward to your continued report as the court continues tomorrow at 9 a.m. in Broward County, Florida. Thank you so very much.
Thanks, Linda. Thanks so much.
All right. And, I do have my 2 guests that have been standing by in this matter, but I think we're going to take a quick break first before we discuss with them what's happening and what Terry told us and what the cross-examination was. But you will hear from Bob Mata and Tracy Walder, but you have to stay with me here at the Law and Crime Network, and I will see you on the other side.
Hi, everyone. Welcome back to Law and Crime. I'm Michelle Yu. Our trial coverage continues in Broward County, Florida for the YNW Melly double murder trial. The South Florida rapper and defendant in this case, whose real name is Jamell Demons, is charged with 2 counts of first-degree murder for the 2018 shooting deaths of Anthony Williams and Christopher Thomas Jr. Now, if convicted, the 24-year-old faces the death penalty. The state has officially rested their case for today, and the defense case is slated to begin tomorrow morning. Law and Crime's correspondent Terry Austin joins us now from outside that Broward County courtroom. Terry, good afternoon to you. The state has officially rested their case after days of Detective Mark Moretti's testimony. How did the jury react to Detective Moretti's testimony, especially when it came to the infamous "I did that" text?
Well, that was the most interesting part of his testimony, and the prosecution saved that for the very last word. When she was reading those texts, it was clear in her mind that that was an admission by YNW Melly. And we heard Mark Moretti, remember, he's the lead detective on this case. We heard him say, yes, this is what the text said. I did that. Shh. But when he was cross-examined, it was clear from what the defense was trying to say that it wasn't Melly who used the word that, T-H-A-T, because he always uses the word D-A-T. I think the jury was listening intently. I think they were interested to see whether or not that really was Melly who texted those messages. And at the end of the day, it's really going to be up for the jury to make that determination. One thing I'll add, Michelle, when the prosecution got back up to do her redirect, one of the things she pointed out was there were other times that Melly used the word that, and he spelled it T-H-A-T. So I just saw the jury sort of looking and going back and forth between the attorneys and the witness, and I think they're trying to figure out, was it him or was it someone else?
So you pointed out what the jury was not thinking, but you pointed out how the jury reacted to all this. How was the defendant's demeanor when the "I did that" text came out?
You know, it's so interesting to me. The first couple of weeks, we know that YNW Melly was a little bit more animated. Now he's really paying very close attention. He's quiet. He's looking down. He's looking at the monitor that's next to him, and he's looking at the witness. There hasn't been any sort of smiles or laughter today. I think he's just very focused. I wouldn't say he's worried. I wouldn't say he's concerned. I wouldn't say he's not interested. He is really basically just plain vanilla, listening intently. And in fact, if I had a client, this is exactly the way I would want my client to behave when they are sitting and they are listening to what's going on in that courtroom. No way you can tell what he's thinking because he's just focused on the trial and not looking any way, one way or the other.
So, Terry, with that being said, do you think that was the slam dunk the prosecution was looking for?
I don't. I do think they scored some points, Michelle. I want to be very clear with that. When she did her opening statement, Christine Bradley said, you are going to see the defendant. You're going to hear him say, I did that. Shh. And she really highlighted that. She underscored it as though it was going to be a huge point. Well, it was a point, but I don't think it was a huge point because it is unclear. First of all, the context. What was he saying that in response to? It seems to us that he was saying something in response to a question by someone else who was asking, are you okay? Gambino was the person on the other end of that. And, his response, I did that, shh, what does that mean? So I don't think the jury can understand really that is in response to, well, did you commit this crime? So it's not a smoking gun in that sense. And I do think that when the defense got up there, they took a little bit of wind out of that sail by trying to say someone else could have written those words.
So the defense case is expected to begin tomorrow morning. What do we expect out of their case? And do you know who they plan to call to the witness stand?
Well, they had a very long list of witnesses, but the one witness they mentioned today that they are going to call tomorrow is Brendan Collins, and he is that cast analysis. He's that cell phone data analysis, and so he's going to come back to talk about whether or not you can actually pinpoint where these cell phones were. Remember, it's not anything to do with where the people were, but the cell phones. And I think what the defense wants to try to do is to say, look, this longitude, this latitude, it could be a huge area. You can't basically say where exactly the phone was. And even beyond that, this witness is not going to be able to say that someone specifically like YNW Melly was holding that telephone. So he's an FBI expert. He's someone who has experience in cell phone analysis. And I want to say they're going to call him back to refute some of the messages, some of the ideas that the prosecution was trying to set in the jury's mind, that this was actually happening right here. Here's the scene of the crime. Here's his phone. Here's that 9807 number. Here's YNW Melly. He's probably the one holding it. I think what the defense wants to do is say none of this is exact science.
Terry, I believe tomorrow will be day 16 of this case. How soon do we expect the jury to get the case?
Well, I think they could very well get the case, if not tomorrow, the next day. This is Monday, tomorrow's Tuesday. I think Wednesday, Thursday by the latest. One of the things the judge was telling both sides, get ready to do your jury charges, get ready for your closing arguments, because right after this witness that we will hear tomorrow, and you said it already, Michelle, the prosecution has rested. So now we have the defense. I don't expect that Brendan Collins will be very long at all. And so let's say he's an hour or two, and even if an hour or so for cross-examination, those jury charges are going to be done, and then the closings will occur. The interesting thing is Friday is always quiet in this courtroom. So if the jury gets the case Thursday, they will be off on Friday. Another interesting thing is the judge did say they will be sequestered. So I imagine that they will be sequestered Friday as well. So I don't think they'll get Friday off if they're deliberating.
All right, Terry Austin, now that the case has rested for today, I do hope you get some rest, as you'll have a lot going on tomorrow morning for a fresh new day in court for day 16 in the YNW Melly case. Thank you so much for your insight, as always. Great job down there. All right, we're going to take a quick break here on Law&Crime, but we do have much more coverage on the YNW Melly trial on the other side of the break, so don't go anywhere. We'll be right back. Welcome back to Law and Crime. Our main focus continues to be what's happening down in Broward County, Florida for the YNW Melly double murder trial. The South Florida rapper and defendant in this case, whose real name is Jamell Demons, is charged with 2 counts of first-degree murder for the 2018 shooting deaths of Anthony Williams and Christopher Thomas Jr. Now, if convicted, the 24-year-old faces the death penalty. The state has officially rested their case, and the defense case is slated to begin tomorrow morning. Court has adjourned for the day, but I do want us to recap the redirect testimony of Detective Mark Moretti. Let's head into that courtroom to hear more.
That's not a fair and accurate statement of all of the suspects. Who needs to be added to that list before you could say it actually describes the people that are suspects in this case?
It's missing the defendant's name.
And who would that be?
Jamell Demons.
Okay. With regards to the first thing counsel asked you about, the word that. I want to go to what's been previously put into evidence as State 64. And this may be so kind of switch to another source. Gary was kind enough to get our screen working. Going to what's highlighted on the screen. What's the name of the song by Mr. Demons? What is that one called? In the bottom right-hand corner of the screen?
Melly fixed that THAT_01.mp3.
Okay. In terms of going through the various messages. Yes, please. Going on previously in evidence, it states 106. Is that same song sent back and forth between Mr. Williams and Mr. Demons?
Yes, ma'am.
That was from states 106 for counsel. Going to states 112. Statements, and this is the conversation between the 6942 number on September 16th of 2018. How does the defendant spell that?
THAT.
Okay. On November 18th of 2018, how does the defendant spell that?
THAT.
On December 31st of 2018, how does the defendant spell that?
THAT.
Counsel asked you about that red Mitsubishi. I'm going now to state 118, the Facebook. Specifically page 293. Starting on page 294, the conversation, who on October 28th of 2018, who is that being sent by? Who is the author of that message, hey baby?
Gianna Thompson.
On October 30th of 2018, 21:24:13 UTC. There's a what is this message from Ms. Thompson to Jamell Demons' Facebook say?
You gave me a truck, baby? Question mark, question mark.
Do you know what truck that is?
The red Mitsubishi.
Before that, October 28, 2018. What does Jamell Demons send as a message to Janet Thompson?
My lawyer and my label told me not to talk to nobody.
Excuse
but I'm
me, I
taking-
have an objection. May we approach? Yep.
Told me not to talk to nobody.
But I'm taking care of the funeral, and your family is going to be good for life. But I know it won't replace this heartbreak ever, but it's the least I can do. Then 4 emojis that we don't know what they are.
On October 28, 2018, how does Janet Thompson respond? You can just read the first through ashes.
I don't want him buried. I want his ashes.
So Detective Moretti, counsel asked you about that list of suspects.
Yes, ma'am.
On Bentley. I'm going to go to in States 70, page 132. And this is in the chat with Chapa on August 27, 2018. Is the name Bentley referred to there?
Yes, ma'am.
And if you could say, and I just want you to read from here to here.
Bentley told him not to sell it. Not to sell it.
So you talked about a charm or something. Is this the post regarding this necklace from Walmart?
Yes, ma'am.
And what is the date on that?
8/25/2018.
So is Bentley and the person from Walmart the same suspect?
No, ma'am.
Okay. What information do you have in this case that puts Montrell Rule at the scene?
No information whatsoever. He was in jail at the time.
So his alibi checked out.
Yes, ma'am.
So we can cross him off that list. Let's go to Chris Thomas Sr. Any information whatsoever that puts him at the scene?
No, ma'am.
Any indication whatsoever that he wanted to kill his own son?
No, ma'am. No.
Cross him off the list. Going to David Hedgepath, Crucial Almighty. You indicated you first wrote a search warrant for his involvement on October 31st of 2018.
Yes, ma'am.
Anything that ties him to the scene in your mind?
None whatsoever.
In terms of the follow-up investigation with his work records,
Yes, ma'am.
after you reviewed them, did you move on in your investigation?
Yes, ma'am.
Going now to Cortlen Henry. Is Mr. Henry involved in this case?
Mr. Henry is a co-indicted defendant.
Going now in terms of the Jameson Francois. Does Mr. Francois have an alibi?
Yes.
How so?
He was at his house at the time.
And how do you know that?
His wife.
How else do you know that?
Southside dad.
What about Jay Green? Counsel wouldn't let you answer the because, so I'm going to ask if you complete your answer. So what you say because Jay Green?
Because later that day, the defendant reached out to Jay Green, had a conversation with him on Instagram, and the conversation was, "I love you, fool."
Continuing on to Frederick Givens. How do you know that he wasn't there at Pembroke Road when he was 27?
Based upon the text conversation, he is the one that went to the scene, well, to the pickup point to pick up the defendant and take him back to his house.
Okay. And in terms of the location of the defendant going back to his house, whose house do you mean?
Frederick Gibbons' house.
Frederick Gibbons' house. Does Mr. Demons' phone connect back to the YNW Castle?
That day, no.
Herc, Goon, and Gina. Do you have any indication whatsoever that either of those individuals were here in the state of Florida on October 26, 2018?
No, ma'am.
Fondo Rondo. Who is that?
I don't know, ma'am.
And in terms of when you're interviewing a witness, do you advise them of what perjury is?
Yes, ma'am.
Is that done in every single one of your statements?
Yes, ma'am.
In terms, there's a lot of talk about surveillance footage and going and looking at various surveillance footage on that. Does the business have an obligation to cover the roadway in front of it?
Most of the time they don't.
Why?
It's not in their interest. They're most places like CVS, Walmart, they're more focused on what's going on inside.
So in terms of all the various places that you went to, did you collect evidence if it didn't show anything?
No, ma'am.
In terms of the cellular analysis that you did,
Yes, ma'am.
were you able to compare and contrast the cellular analysis you did with the one that the FBI did?
Yes, ma'am.
Were there any discrepancies between the two?
Objection.
What's the objection?
Conclusion on it and speaking for another witness.
Overruled.
Were there any discrepancies between those two?
No, ma'am. My report mirrored their report.
Nothing further, Your Honor.
I have just a few with the court's permission.
Yes.
Would you agree with me that if you don't check the surveillance tapes, you have no idea what's on them?
Correct.
So you don't know what's on any of these cameras, on all of these companies that had cameras up and down Miramar Parkway, Pines, and the route that you took the helicopter ride on. Right?
We were able to walk it out and assess what the cameras covered and what it did not cover.
Frederick Gibbons, you said purportedly my client went there. Certainly you got a search warrant to search that house for blood, clothes, or anything of that nature.
Sustained.
Did you get a search warrant for...
Excuse me, I sustain the objection.
You mentioned Frederick Gibbons. Is that correct?
Yes.
You mentioned and just told this jury that supposedly my client went to that house immediately after this incident, correct?
Yes, sir.
Did you get a search warrant for that house? Verify or collect evidence?
Outside the scope.
Overruled.
We did not find out the exact location of Frederick Gibbons until we actually seized the cell phone, analyzed the cell phone. Because if you look back at previous statements, no one could ever give us the address. So by the time we actually discovered what his address was, he was no longer living in that area.
So the answer is no.
Correct.
Would you agree with the premise that you won't find any evidence
Objection, Your Honor.
Sustained.
if you don't...
Objection, Your Honor.
Excuse me. If. Sustained. Rephrase the question.
The individual, may I do it from here? I'm sorry, Judge.
Yes, sir.
The individuals that you say had no connection to this incident, you did not investigate, correct?
Incorrect.
Did you investigate Wanda Quanda?
Don't know who that is.
Did you investigate Jay Green?
Yes.
Did you investigate Bentley?
Couldn't determine who Bentley was.
Can I see that list? Did you investigate Walmart incident?
No, sir.
Did you mention Montrell Road?
Yes, sir.
Did you investigate his sister?
Yes.
Did you investigate her?
No.
Did you investigate Goon?
No.
Did you investigate Gina?
No.
Thank you.
Any further students, counsel?
Briefly, Anna. Detective Moretti, do you look at any one piece of evidence by itself?
No, ma'am. Our decision to make an arrest is based upon the totality of the circumstances. It's all the factors encompassed in the case, not just one person's name, one text message. It's everything.
Nothing further, Your Honor.
Thank you. Is this witness excused?
Yes, Your Honor.
Thank you, sir. You may step down. You're excused.
Thank you.
Madam, you want to call your next witness?
At this time, the state would rest.
Ladies and gentlemen, I need a few minutes with you.
Now that is something to talk about, as we just saw testimony from Detective Moretti from earlier today. I am now joined by criminal defense attorney Natalie Whittingham Burrell. Natalie, let's get your take on the whole I did that versus DAT, D-A-T. Do you think the introduction of that message between YNW Melly and PZ Gambino was the slam dunk the state was looking for?
I actually think it will be, honestly. I think that's it. To be totally honest with you, I think the defense has put up a really, really good argument. They've really tried very, very hard, but saying I did that in response to how are your friends who have just been shot, what's going on with them, is highly incriminating. And I think that the prosecution recovered themselves when they said that he's used THAT in text messaging previous to that. The defense did a good job of raising the question of whether or not YNW Melly is the one who's texting from that phone at all times. That is a question that's there and something the jury can hang their hat on if they want to find reasonable doubt. But I think that common sense would dictate I did that in response to that question as an admission.
And Natalie, going back to the cross of Detective Moretti there, were there any points or questions you think the defense missed?
His testimony was so all-encompassing. It was multiple days worth of testimony. I think that what they're going to be doing mostly is arguing. And you saw that a lot of objections there were sustained because basically the questions towards him were argumentative. I don't really think it's a good idea to allow him to clean up any of their mistakes, and they should just save that for their closing argument. So I think that they were good. It was a good trial strategy to limit the questions to, you didn't investigate all of these people and you didn't do a search warrant on this particular residence where YNW Melly went directly after the shooting. I think that it was a very curtailed cross-examination just for them to avoid giving up any of the arguments that they're going to have in the future, letting them kind of rehabilitate themselves.
So the name David Hedgepath has been mentioned numerous times during Moretti's testimony about being a potential suspect here. What is your take on that? And do you think authorities did enough to investigate into other possibilities?
Well, I think that that's the defense's biggest argument, is that this was a rush to judgment. You had YNW Melly here, and all they did was chase after YNW Melly in Bortlen because he was in the car, and they excluded any other potential suspects. And so I think that they made great hay of that. We'll see what the defense does in their own case once they start introducing their own evidence, if they introduce anything on that. But follow every lead, because if you don't, even in a case, I think, where they have something that's incriminating like that statement, that's going to be something niggling in the back of the jurors' minds where they'll be thinking, well, what about this other guy? What was his potential involvement?
Well, we won't have to know for long what the defense is going to do, because tomorrow morning the defense is expected to take over in day 16 of this trial. Thank you so much, Natalie. We're going to discuss more, but we do have to take a quick break here on Law&Crime, but so much more trial coverage on the YNW Melly double murder trial. Stay with us. back to Law and Crime. Our main focus continues to be what's happening down in Broward County, Florida for the YNW Melly double murder trial. The South Florida rapper is charged with 2 counts of first-degree murder for the 2018 shooting deaths of 2 of his friends, Anthony Williams and Christopher Thomas Jr. Now, the state has officially rested their case for today, and the defense case is slated to begin tomorrow morning. Court has adjourned, but after Detective Moretti was excused from the stand, there were discussions outside the presence of the jury. So let's listen in and then discuss.
Lieutenant, so the state rested. Are we still on schedule for tomorrow then? You said Brian Collins is going to be your witness, is that right?
Yes, Judge.
Yes?
It's a possibility, Judge. Possibility.
And he's available, Ms. Bradley?
Yes, Your Honor. Last council had asked for him to be here at 8:30. He said he could be here at 8:30.
All right. So, assuming that you told Mr. Collins, is there any other witnesses that you anticipate calling tomorrow now?
We may have one more witness.
All right, so and is the state going to have any rebuttal?
Depending on if they call the one civilian, there is a possibility of that.
So it's a possibility, and it's going to be long or short?
Very short, Your Honor.
So are you all telling me or suggesting to me that you think you'll be over by, let's say, lunchtime tomorrow?
Yes, Your Honor.
Mr. Adelstein?
Yes, sir.
Yes? No.
Yes.
So I know you asked me to just adjourn or let the jury go now, so nothing's changed in that regard, correct? I'm just going to excuse the jury, tell them to be back here tomorrow at 9?
Yes, sir.
Yes, Your Honor.
All right, and any objection if I just have Gary tell him to see you back tomorrow at 9?
No.
No, you're.
All right, so Gary, can you tell him, excuse him, walk him out?
Absolutely.
Thank you. So you have any motions?
Yes, Your Honor. We would move for a judgment of acquittal on the premise that the state has not presented a case sufficient for a jury to rely upon and for a conclusion of guilt beyond a reasonable doubt. Beyond the several suspects who were not investigated, with the contention is they have no connection to the case, which would be a difficult contention to make, having not investigated them. The DNA evidence is inconclusive. The cell tower evidence, the witness said when it's specific, it's not accurate, and when it's accurate, it's not specific, and gave us essentially a statement that in certain instances he was really able just to say that 2 phones were in the city of Miramar. And so they have no, this is a circumstantial case, and the circumstances themselves lend to a multitude of various scenarios. And in that instance where a set of circumstances can lead to the conclusion of guilt and conclude to the conclusion of innocence, a jury would be required, and therefore we would argue that such a level of proof doesn't rise to the level of proof beyond reasonable doubt. What it does is it invites the jury to speculate and find proof less than proof beyond a reasonable doubt, where other scenarios of innocence exist. And so we would respectfully move the court for a judgment of acquittal.
State?
Your Honor, the state would also make sure that counsel is aware of Bush v. State 295, 7th, 3rd, 179. That's a 2020 Florida Supreme Court case in which there is no special circumstantial standard of review on the judgment of acquittal. The state has put forth competent evidence to support each and every element of first-degree premeditated murder as to both count 1 and count 2, that the defendant is the individual who committed said crimes, that the victims are the ones that were deceased, and that there is a premeditated killing.
I'm sorry. We also renew all of our previously made objections during the motions to suppress before Judge Siegel. and all of our objections that we made during the course of the trial and the motions for this trial.
Thank you. All right, so I'll defer ruling, take it under advisement unless there's some other response. Is that yours? No other response?
That's it, Your Honor.
So I'll defer ruling, take it under advisement. So the plan going forward now is we're going to hear from, or may hear from Brendan Collins tomorrow. You may have one additional witness other than that, correct, Mr. Adelstein?
Correct.
And the state may or may not have one rebuttal witness, but if that's the case, it'll still be done by, let's say, noon tomorrow, right?
I think that's a fair assessment.
Okay. So then tomorrow afternoon, you're going to read the jury instructions tonight,
Yes, sir.
and we're going to go over, we'll have a charge conference tomorrow afternoon. And we're anticipating then doing closings. I'm just going to tell the jury, you're going to find out tomorrow morning whether you're going to be available Wednesday morning or not.
Yes, sir.
So if you're available Wednesday, we're going to do closings on Wednesday. If you're not available Wednesday, I'm just going to tell the jury to come back on Thursday. Is that what we all agreed to? Yes?
Yes, sir.
Yes, sir.
All right.
I would prefer to be here, Your Honor. I understand there are higher authorities compelling my presence elsewhere, but that is my preference would be to be here and be closing on Wednesday.
My preference is to be home, Judge, to be candid.
Understood, but you suggested there's some motion filed or something like that where they're saying they're not ready in the other case.
Correct.
So I don't know anything about it. Respectfully, it's just, Judge Fine requested your presence a couple of weeks ago. You had 250 jurors coming in, doesn't want to waste their time. All right, so I acquiesced to it. But in any event, so we'll just play it by ear, and we'll see everybody back tomorrow, 9 a.m., and we'll sort it out then. All right?
Yes, sir.
Thank you.
All right, I'm still joined by criminal defense attorney Natalie Whittingham-Burrell. And Natalie, we saw the defense once again motion for an acquittal there, and it was denied by the judge. What do you make of that, and is it a last-ditch effort?
Oh, no, this was in the normal course of the case. So at the close of the prosecution's case, the defense moves for a motion for judgment of acquittal, which are almost always denied. It's in very rare circumstances where they're granted, but you have to raise them when the state closes their case, or else you waive the issue for appeal. And what you're asking is that the judge find that in the light most favorable to the state hasn't alleged anything which would rise to the level to give that charge back to the jury. Sometimes you go charge by charge, but here the defense just chose to do kind of a sweeping motion about the entire case, the strength of the whole case. And this is just so that they can preserve the issue. And as long as they raise it in a timely and appropriate manner, then the appellate court can review whether or not any of those charges should have been acquitted before going back to the jury.
Here's the thing, though. It is the state that has the burden of proof at this point in the trial. Do you think they met that? Or if you are a juror, are you seeing some reasonable doubt here?
Well, the jury's not supposed to make any decisions until they've heard all the evidence. That includes the defense's evidence. But at this stage, where the court is looking at things in the light most favorable to the prosecution has at least reached that low burden at the motion for judgment of acquittal, or MJOA stage. They've put out some evidence to allege that YNW Melly was present at the time of the crime, that he committed the crime, and that he attempted to cover up the crime. That's the evidence they put forward. Now, whether or not the jury believes that, the state's case, the state's theory of the case, that's completely up to the jury, and we will not know until they come back with a verdict.
Natalie, the bottom line is this. YNW Melly is facing the death penalty. I mean, do you think he took the whole process seriously throughout the trial, knowing that he is facing such a serious consequence?
You know, it's such a shame because it does seem like his attorneys took the case very seriously. But at least for the first week, YNW Melly did not seem to appreciate how serious these charges were against him. Not only did the jury view him making various gestures and smiling and laughing with various people, including his attorneys, throughout the trial, but the judge has observed the things that he's done even outside of the view of the jury, like blowing kisses at people. And we have to think that no matter what verdict the jury comes back with, it's the judge that ultimately says, this is your sentence. And so you really want to be careful with the type of demeanor that you have, even for someone who is factually innocent. They actually did not commit the crime. You want to appear to be taking the case as seriously as it is, which is the death of two people that are supposed to be your friends. It wasn't the appropriate affect. He's fixed it, but he didn't seem to be taking it seriously the first week. And you can see that as they're getting closer and closer to the end, he's becoming more serious and somber.
Yeah, indeed. It seems like it's a tale of two Mellys. Tomorrow will be day 16 of this trial. In the beginning, he was a much different person, much more loose, much more cocky, looking in the courtroom, blowing kisses, as you had mentioned. And now we see a very different version of him. But the question is it too late? All right, that is the question. We will know more tomorrow as the defense takes over the case. Thank you for that, Natalie. We're going to take a quick break, though, but Natalie's going to be back because we're going to discuss more of the YNW Melly trial in just a moment. Stay with us. We'll be right back. again from our Law and Crime studios here in New York City. Our attention is on the YNW Melly double murder trial. The state has officially rested their case for today, and the defense case is slated to begin tomorrow morning. Even though court has adjourned for the day, I do want to point out and have us take a quick listen to the cross-examination of Detective Mark Moretti. Then we'll get Natalie's thoughts before we have to sign her off at the end of the hour.
Did you get a search warrant of the house in November at all?
You mean for which house, sir?
The house where Melly lived.
No, sir.
How about December?
They were already gone at that point.
You could have looked for blood, traces of blood, because we saw that you sprayed this agent on things and miraculously blood surfaces. You know that.
Yes, sir.
Did you do that?
No, sir.
You mentioned to the state that you spoke to an Adrian Davis and a Dontavius Withers, correct?
Yes, sir.
They were the two of the individuals that originally left the studio
Yes, sir.
and got into the red Mitsubishi.
Correct.
You learned from that. I haven't even asked a question.
He's watched himself.
And with that, criminal defense attorney Natalie Whittingham-Burrell has been kind enough to be with me this hour to discuss. And before you go, Natalie, we just heard a portion of the cross there that discusses Detective Moretti not looking for blood traces at the home YNW Melly and the victims where they lived at the time of the shooting. Do you think that the investigator, it was an oversight for him, or was there no need to go to the home?
Oh, I definitely think they should have gone to the home. I think that they should have gone to the place where he's alleged to have run to directly afterwards. I think that they should have done a more thorough job of ruling out everyone, but ultimately it's going to come down to that statement. And so while, yes, they could have done a more thorough investigation, I think it was incumbent upon them to do a more thorough investigation. And the defense is rightfully pointing out those gaps. I don't think it's ultimately going to matter when you have such an incriminating statement.
So the defense takes over with this case tomorrow morning. Give us a preview, Natalie. What do you expect to happen?
I expect for them to call into question the GPS data location information, which in the real world, it is true that that location information from the phone is not very precise and accurate. It kind of gives you broad strokes of where a phone may be, but it's not, down to the millimeter of where a person or phone is. And if they're going to call any fact witnesses, I would hope that they're going to call on someone to either provide Melly with an alibi, which I have doubts that they'll be calling on someone to do, or calling on someone to kind of call into question the use and ownership of that phone. So those are the things that I think that they should be touching on. And if they have their own expert to combat that crime scene reconstruction expert who said that the victims were shot from the rear of the car from the inside and not from the outside before they were killed, then that would really, really be helpful to their case. Without it, I think they're going to have a tough time.
Natalie, the judge mentioned before that Wednesdays might be closings. When do you expect the jury to get this case? We have about 30 seconds.
If Wednesdays are closings, then probably Thursday morning.
And what do you think the results will be? I hate to ask these questions, but very quick.
You can never know. Juries are unpredictable things. The things that I'm picking up on and saying, that's so bad, a juror may completely disregard that. So I'm not going to make any predictions.
All right. Well, we will just have to see. Thank you so much, Natalie, for coming on. Your insight analysis is always valued. We'll be right back. Much more Law and Crime after this. Welcome back to Law and Crime Network. I'm Michelle Yu. If you're just joining us, we have been locked in on the trial coverage in Broward County, Florida for the YNW Melly double murder trial. The South Florida rapper is charged with 2 counts of first-degree murder for the deaths of Anthony Williams and Christopher Thomas Jr. Now, if convicted, YNW Melly, whose real name is Jamell Demons, faces the death penalty. Court has adjourned for the day, but I do want us to recap testimony from earlier today of Detective Mark Moretti. He was the lead detective in this case. Let's head into that Broward County courtroom for more.
On October 26th of 2018 at 20:02:18 UTC, what does the YNW Melly account state?
I did that with a smiley emoji.
In terms of what was that in response to from the PZ Gambino account?
Objection. Overruled.
The PZ Gambino account asked him if he was okay, and his response was, I did that, and placed a smiley face emoji.
And the next message from 10/26/2018 at 16:02 from Eastern Standard Time, the YNW Melly account says what?
After that, SHHHH.
Would you tell the jury how he spells that?
That, D-A-T.
D-A-T. Page 2. Will you tell the jury how he spells that?
D-A-T.
D-A-T. Not T-H-A-T. D-A-T, correct?
Right.
Page 3, coming out of 9807. How does he spell that?
D-A-T.
So when Melly spells the word that, you want me to go through all 19 pages? Or will you take my word that every time, coming out of 9807, that's attributed to this young man as writing the message, he does not spell it T-H-A-T, but D-A-T. Would you like to look through them?
No, sir. You're asking me to explain that the one moment he decided to use proper grammar.
One moment, these phone messages sitting there.
One at a time. All right. What's the objection?
Argumentative.
Overruled.
These phone messages that the state introduced sitting on this pages that we painfully went through, he spells it D-A-T, not T-H-A-T, except for this one occasion. Right?
Correct.
What a strange thing. I'm sorry, Judge. I apologize. Now, in addition to that, you told this jury that you attempted to, well, you did get some cameras off of 595 and I-75, correct?
Yes, sir.
Could you tell the jury if you could see who was in each vehicle?
No, sir, you cannot tell.
Could you tell this jury how many people were in each vehicle?
No, sir, you cannot tell.
And you did get a surveillance from Montessori School, correct?
Yes, sir. And McDonald's.
And McDonald's. Well, on Miramar Parkway, for instance, the only surveillance you got was from the Montessori School, correct?
No, Montessori School is on Pines Boulevard.
Okay. Did you get any surveillance from any of the cameras on Miramar Parkway?
More specifics are which one you're referring to.
Okay. How about the CVS that's on Miramar Parkway?
It doesn't cover up that far.
Did you pull it?
We went there.
Did you look at it?
Yes, sir.
How about Applebee's? on Miramar Parkway?
Was there Applebee's on Miramar Parkway?
On we're on Dykes Road. On Miramar Parkway West, on Dykes Road, on the intersection.
Yeah, there's a pharmacy there, but there's no Applebee's there.
Did you go to that pharmacy?
Yes, sir.
Did you pull the surveillance?
No, sir.
How about the Pollo Tropical?
Their videos didn't cover that area.
Did you pull them?
No, sir.
Did you look at them?
No, sir.
How about the gas station that's on Miramar Parkway?
The one just east of McDonald's?
Yes.
Yes, it did not cover the road.
How about the bank that was on the corner of 172nd and Miramar Parkway?
Did not cover the road.
Did you look at it?
Yes, sir.
Did you bring it in?
No, sir.
How about the four-way intersection where there's 4 cameras on 172nd Avenue?
Cameras covering the road.
Yeah,
We
you see the cars driving through.
There's no traffic cameras at 172 and Pines. That seems to be a great misconception when people see those white boxes on top of the cameras. Those are actually control the traffic signals. They're sensors. The old sensors used to be in the road. They would burn out. The lights would not cycle properly. So, but there's no cameras. It's a great misconception.
Okay, then you said the vehicle turned right on and went south on 184th. Is that correct?
Which vehicle?
The Jeep?
Jeep never went south on 184.
Did it make a right turn on 184, the Jeep?
Yes, sir.
That would be north.
Yes, sir.
My mistake. Did you look at the camera at Publix that's on that road?
Doesn't cover the road, sir.
Did you pull it and look at it?
We went there, but it does not cover the road.
My question is, did you look at it?
Yes.
How about Sunset Lakes Elementary? That's there. Did you pull that camera, sir?
No, sir.
How about West Broward Elementary? Did you pull that camera?
Where's West Broward Elementary located at?
On south on 184.
184 and what?
Pembroke Road.
Pembroke Road and 184?
Yes.
I don't know of a West Broward school there at Pembroke Road in 184.
Okay. How about the Walmart?
No, sir.
You didn't look at it.
No, sir.
How about the Audi Market? Did
No,
you
sir.
look at that one?
No, sir.
How about the Walgreens?
No, sir.
You did this helicopter ride in May of 2023,
Yes, sir.
after this trial started, correct?
Correct.
And you did this drive-by in a car with a partner filming it. On what day?
March 2022.
That was 2 years after this incident?
4 years, actually, sir.
4 years. That's why I'm a lawyer and can't be an accountant. 4 years after this incident.
Yes, sir.
And that was all done at the request of the state of Florida, correct?
Correct.
The prosecutors in this case, correct?
Yes, sir.
4 years after the incident.
Yes.
4 years after this young man.
Thank you. Just saying.
4 years after this young man surrendered, correct?
Sustain your question. Ask your next question.
Are pictures taken of the 2 individuals that were shot before they were removed from the vehicle, the Jeep?
No, sir. No, sir.
You immediately go and speak to Cortlen Henry, correct?
Yes, sir.
And we listened to the tape of Mr. Henry,
Yes, sir.
who told you that there were 3 people in his car, correct?
Yes, sir.
Cortlen Henry, the driver, correct?
Yes.
Christopher, and, well, let me get in the right order. In the front passenger seat was Anthony Williams,
Yes.
and sitting in the rear passenger seat was Christopher Thomas.
Yes.
Only those three people when the shooting occurred, correct?
Correct.
You learned that he lied to you about where the drive-by shooting was, correct?
Yes.
You went to, what, 3 different areas to look for evidence of the drive-by of Cortlen, what Cortlen Henry told you, correct?
Yes.
You learned at that time that at first he was labeled a victim, but that he now is lying to the police concerning the shooting of 2 individuals.
He was still listed as a victim that day, even though we knew he was lying to us, but he was still considered a victim at that point.
There is such a crime as lying to the police, correct?
Yes, sir, it's a misdemeanor.
You could have arrested him if you so chose for lying to the police, correct?
You're saying I should have arrested a potential victim of a violent crime on a misdemeanor?
Could you just answer my question? Could you have arrested him, yes or no?
Yes.
And you spoke to him for approximately an hour or 2, correct?
It was about an hour.
Okay. And he gave you the address where he lives, correct?
Yes, sir.
And that address was 18521 Southwest 44th Street, Silver Lakes?
Yes, sir. No, Sunset Lakes.
Sunset Lakes. But he gave you the home address.
Yes.
And he tells you also that Melly lives there, correct?
Yes.
He tells you Anthony Williams, one of the victims, lives there.
Yes.
He tells you Christopher Thomas, the other victim, lives there, correct?
Correct.
And he also tells you that Melly is a recording artist, correct?
Yes.
So the I did that versus DAT, that's D-A-T, reveal was no doubt one of the key pieces of testimony for the prosecution here. It will be interesting to see how the jury will take all this in, especially with the emoji that came after that sentence. And on that note, I'm joined by criminal defense attorney and former prosecutor Florina Altschiller. Florina, we just saw the message that the prosecution originally spoke about during their openings, the whole I did that shh message. What are your thoughts on that? And was this a slam dunk for the prosecution?
I don't think it was a slam dunk, but I do think it's more evidence to suggest that this defendant is the defendant that's responsible here. Certainly that could be interpreted in many different ways. What that is he referring to? Nobody knows. The defense version, though, of I wouldn't send that properly spelled and I would have sent a message with DAT instead, I think is very weak, especially in light of other text messages where it is properly spelled. And so that takes away credibility from the defendant.
I got all that. Now, the prosecution has officially rested. Do you think that they have done all they could for this case?
I think they did a nice job not only putting forward the facts that match the elements, but also anticipating the defense theory that this was a drive-by shooting and debunking that theory. And I think they scored even more points by preempting where the defense was going to go and debunking it than by simply matching the facts to the elements.
Now, the judge says closings are expected the end of this week. So this trial is coming to a near, and we have seen two different sides of YNW Melly in court. In the beginning, we saw a more boisterous side, more cocky, a lot of emotions, blowing kisses, smiling. But then towards the end of the trial now, there's a much more subdued side to him. I'm sure he had people talk to him. Tell us how a jury perceives that progression of the defendant.
I think, and I'm guessing here, of course, nobody knows what's going on in his head, but I think the reality of a very likely conviction is setting in, and the cockiness is fading as his defense of this was a drive-by has, in my opinion, faded as well.
Okay, so you speak of possibly a conviction, and with the conviction comes talk of the death penalty. And in Florida, very different case now with the death penalty and how they handle it, 8-4 ruling. With that being said, with no motive, with no gun and solidification of this case, where do we stand with the death penalty in specifics?
Again, if I had to make a prediction, if we look at the recent case of the Parkland shooter, who a Florida jury chose not to execute, and we're talking about a mass murderer who killed children. Certainly this case is not that, and I don't think this would be an appropriate case for the death penalty.
Very solid point there. All right. Thank you so much, Florina, for joining us this hour as well. She's going to stick around with us. We're going to talk more about this YNW Melly trial in just a moment, but we do have to take a quick break. We'll be right back. You're watching Law and Crime. Thanks for being with us here on Law and Crime. Our trial coverage in the YNW Melly double murder trial out in Broward County, Florida continues. The South Florida rapper is charged with 2 counts of first-degree murder for the deaths of Anthony Williams and Christopher Thomas Jr. back in 2018. Now, if convicted, YNW Melly, whose real name is Jamell Demons, he does face the death penalty. Court is done for the day, but I do want us to recap testimony from earlier of lead detective Mark Moretti. Let's go back to court.
And learned from the testimony that $16 million went into Jameson Francois' bank account.
Over a 30-month period, yes.
Okay. So, and he was the business manager of this 19-year-old young man.
Yes.
You learned later, correct?
Yes.
A rather successful, would you say, recording artist.
I really don't understand the music business. I don't know how the money's made, how it comes in.
I'm not asking you that. Someone who earns $16 million in 30 months legally is pretty successful, wouldn't you say?
Well, I don't, like I said before, that we could never determine the amount of money, what was, because Mr. Francois had other clients, so we could never isolate what specifically is made by one artist over another.
Okay.
We just knew the money was there.
So, you knew that the 2 victims, the driver of the car that lied to you, and Melly lived, and you had the address at the same house.
Yes.
You also learned about that time, and you mentioned it briefly, that a text message came out from a crucial almighty.
Yes.
And that text message was, we were just aiming at YNW, correct?
Yes, sir.
And it had a picture of him with a target, correct?
Yes, sir.
So it would be fair to say on October 26th of 18, Crucial Almighty, which his real name was David Hedgepath, was suspect number 1 based upon that.
It was a person of interest. It was something to look at.
When did you, since you knew this on October 26th of 2018, when did you decide to talk to the David Hedgepath, Crucial Almighty, who said he shot at this young man inside a Jeep? What date?
I first did a search warrant into his social media account where the comments came from, which then was able to determine a better picture of Mr. Hedgepath was. So it was probably maybe 2 years later when we interviewed Mr. Hedgepath.
2 years later. That would be in 20?
Yes, sir.
A year after this young man surrenders to you, to the police?
I'm not sure the exact date, but
February of 19.
okay.
Would you agree it was 2 years after that?
Yes, sir.
And you interviewed him after the case was closed, correct? Because it was closed at the time of the arrest
Yes, sir.
of Melly, correct?
Yes, sir.
You also learned from Cortlen Henry that they were having a problem with a guy named Benton.
Yes, sir.
I'm going to label him as suspect number 2. Who is Bentley?
You never could identify him.
So last name unknown.
Correct.
You also learned that there was a problem at Walmart where they got jumped and I think a necklace or a bracelet was stolen.
A little pendant fell off one of them, yes.
Okay. Did you go to Walmart to investigate that?
No, sir.
I'm going to make him suspect number 3 so far. And I'm going to just label him Walmart with a question mark. Fair enough?
Fair enough.
Did you bother to go and attempt to pull the surveillance of Walmart because they keep their tapes for a while?
Not a while, sir, but usually about 30 days.
Did you go to Walmart to attempt to see if it even didn't exist?
No, sir.
All right, a lot to dissect there as I'm still joined by criminal defense attorney and former prosecutor Florina Altschiller. Florina, we just listened to defense attorney Stuart Adelson ask the witness about potential other suspects. Do you think authorities explored the possibilities of other suspects enough?
I think that one of the best defenses often is the other suspect defense because it does raise reasonable doubt. And oftentimes, like here, authorities don't explore other suspects enough when they think that the suspect that they have, the defendant here, is the person who did it. When they think they have an open and shut case, they don't explore other suspects. And here there was sufficient evidence to suggest that the guy that was in the car with them for a gun that was shot within the car, not through a window from the outside, was the person who did the shooting.
Well, also in this interrogation here of lead detective Mark Moretti, Adelson tried to paint this picture of Moretti as someone who was not responsible and someone who made threats to people. Do you think that mattered at all to the jury when it comes to his credibility?
I think it's going to depend on how savvy this jury is. I know from experience that that's normal police technique, and I've seen plenty of investigators who are way worse in their interrogation techniques. And by worse, I mean more confrontational, they lie, but it's effective and it's absolutely normal police interrogation technique. I think that this jury is going to be smart enough to not have that take away from this detective's credibility and to understand that that's pretty standard police work.
Well, according to our Terry Austin, who is down in Florida covering this trial, she says that the jury has been very sharp, just listening to every word that everyone has been saying, looking at Melly's demeanor. So they've really been hands-on on this trial. So I think they're doing their job, hopefully down there in Florida. All right, thank you, Florina, for that. We're going to have much more trial coverage ahead. We do need to take another quick break, but we're going to break down some other aspects of this trial when we come back. Stay with us. are back talking about the YNW Melly double murder trial out in Broward County, Florida. The South Florida rapper is charged with 2 counts of first-degree murder for the deaths of Anthony Williams and Christopher Thomas Jr., both his friends, back in 2018. Now, YNW Melly, whose real name is Jamell Demons, could get the death penalty if he is convicted. Court is adjourned for the day, but I do want us to recap now testimony from earlier of lead detective Mark Moretti. Let's go back to court.
We then, during October 26th, get the surveillance tape of the people coming out of the recording studio, correct?
On which date, sir?
The 26th.
Yes, sir.
You respond to the hospital in the morning.
Yes, sir.
By mid-afternoon, you get the surveillance tape, correct?
Yes, sir.
You identify, do you not, by the end of October 26th, all 8 people that left the recording studio?
I think we had more like the 27th, everyone was pretty much done.
Okay. By October 27th, you identified Cortlen Henry, correct?
Yes, sir.
Anthony Williams,
Yes, sir.
Christopher Thomas,
Yes, sir.
Trevon Glass,
Yes, sir.
Melly,
Yes, sir.
I'm missing 3.
Jacoby Mills and
Jacoby Mills,
Dontavius Withers
Dontavius Withers, and Adrian Davis. All 8 people that left the recording studio, and 2 had passed away, correct?
Yes, sir.
And you knew where all 8 of them were living, correct?
Yes, sir.
And that was at the 18720, whatever that address I read off before.
The Sunset Lakes 184 Southwest 44th Street.
You had that address, correct?
Yes, sir.
And you had observed the bloody scene of inside the Jeep, correct?
Correct.
And you knew that Cortlen Henry had lied to you.
Correct.
So you certainly, at that point, obtained a search warrant to look at that house to see if you could find any blood, any gun, or anything to tie up what happened in that car, correct?
There is no way we could have got a search warrant for that house because there was no nexus to the crime to the house. And I have to establish a nexus between the two or the judges will not sign the warrant.
Did you even try, sir, to get a search warrant and go in front of a judge and say, I got 8 people who left the studio. They all live in the same house. The driver of the vehicle we interviewed lied, and the inside of the Jeep is covered in blood. And we're looking for the gun or guns and the bloody clothes involved in this. Did you bother to do that, sir?
So like I said before, there was no connection between the house and the crime itself. Now,
The answer-
where we had blood, where we had evidence, where we had instruments of a crime, we did search warrants. Anytime we had a nexus between the two, we did a search warrant. We never had a nexus between the two. We even went to that house that day, knocked on the door, there was no one there.
You could have secured that house by officers standing in front of it and at least come to this jury and say, I went to a judge, explain to the judge, 8 people live in a house, 8 people left the studio, and a few hours later, 2 people ended up dead, and the driver of the vehicle lied to us about everything concerning the shooting. You could have done that, couldn't you?
No, that's not how that works, sir.
Not how it works. Fair enough. Did you get a search warrant of the house in November? At all?
You mean for which house, sir?
The house where Melly lived.
No, sir.
How about December?
They were already gone at that point.
You could have looked for blood, traces of blood, because we saw that you spray this agent on things and miraculously blood surfaces. You know that.
Yes, sir.
Did you do that?
No, sir.
You mentioned to the state that you spoke to an Adrian Davis and a Dontavius Withers, correct?
Yes, sir.
They were the two of the individuals that originally left the studio
Yes, sir.
and got into the red Mitsubishi.
Correct.
You learned from that. I haven't even asked a question.
Hey, watch himself.
I want to go back to October 26th.
Yes, sir.
Leave the hospital. You go to various areas to look for a drive-by. And you learn that Cortlen Henry lied. Okay?
Yes, sir.
You do not get a search warrant for the Jeep.
Yes, sir.
And in fact, the Jeep is searched on October 26th, correct?
Yes, sir.
And the purpose of that was to photograph it, correct?
Yes, sir.
Process it for fingerprints and DNA,
Correct.
and to collect all the physical evidence with inside the Jeep that could lead to who did this, correct?
Correct.
And that was done over several hours, correct?
Yes, sir.
In fact, it was done by at least 2 crime scene technicians.
Yes, sir.
Now, there was also the red Mitsubishi that was seen leaving the area, correct?
Yes, sir.
With several people, correct?
Yes, sir.
That you ended up interviewing over the course of this investigation, correct?
Yes, sir.
Did you, in fact, search the red Mitsubishi at any time?
No, sir.
Did you, in fact, process the red Mitsubishi to get fingerprints to determine who was inside that vehicle?
No, sir.
Had you done that, you could have obtained DNA.
Objection, speculation.
Sustained.
If you did that, that could verify, would it not, whether or not Melly got inside that vehicle. Right?
Not necessarily.
But it could have.
Possibly, yes.
You interviewed, as you've indicated, Dontavius Withers again, correct?
Yes, sir.
At the end of October 27th, Melly was not in the Jeep during the shooting, according to your investigation, correct?
Repeat that question.
At the end of October 27th, your information indicated that this young man was not in the Jeep at that time when the shootings occurred, correct?
That was based upon the false statement of Dontavius Withers.
You say false statement. You have Cortlen Henry who told you this, that he wasn't there, correct?
You're saying?
Sustained.
You learn that the day of them going to the studio, that Christopher Thomas and Anthony Williams went to the flea market.
I don't know which two went. I could have sworn Dontavius went to the flea market. Maybe it was Chris Thomas and Anthony Williams.
And you've already indicated you don't go there to verify or prove or disprove.
Correct.
On October 31st is when you obtained a warrant on David Hedgepodge's Twitter account. I think you testified. Correct?
Yes, sir. And you said October
31st?
Yes, sir.
Halloween day. Correct?
Yes, sir.
But you don't interview him until 2 years later, 2 or 3 years later.
Correct.
All right, we're going to jump out of this, but there is much to dissect after hearing all of that. We're going to talk about it in just a moment. Florina and I will be back. You're watching Law and Crime. Testimony from lead detective Mark Moretti from earlier today. He was the last witness for the state as the defense begins their case tomorrow. Now, criminal defense attorney and former prosecutor Florina Altschiller has been with me this hour to break it all down. And before we sign off, I'd like to get Florina's thoughts here. Florina, after hearing that testimony earlier, should authorities have searched and processed the house that Melly and the victims were living in at the time of the shooting?
I mean, certainly they could have. Certainly that's something that the defense can raise as lack of evidence and something they didn't do to raise doubt. But common sense says, who cares? These victims were shot in a car. The evidence is in that car. Could there be other evidence in the house? Maybe. Maybe the evidence as to motive is what disappeared from what was in the house because they didn't search. But motive is not an element of the crime. And the question here is, who shot them? And that question is quite easily answered by the physical evidence in the car. The defendant's the only person alive. The defendant was in the car with them. The bullet was shot from inside the car.
Well, you talk about the car. Well, why do you think that the red Mitsubishi was not processed?
You know, I think perhaps it should have been processed. And certainly that's a good point to raise by the defense about why it wasn't processed. But I think really at the end of the day, common sense should prevail. And I think the prosecution has done a good enough job to prove beyond a reasonable doubt that it's this defendant who committed this murder.
Well, also, Detective Mark Moretti mentioned that one of the passengers, Dontavius Withers, initially told law enforcement that YNW Melly was in the red Mitsubishi and not the gray Jeep there. Why do you think that is, Florina?
I think, as is common in many cases, witnesses do not tell the truth. Witnesses are sometimes mistaken, and other times they're just lying to try and help either themselves or somebody else. And I think his credibility can very clearly be attacked here. And I don't think that what he said is accurate.
Well, court is adjourned for today. Day 16 tomorrow as the defense takes over, begins their case. How do you expect them to come out bright and early in the morning?
I think they're going to start with an expert to rebut the prosecution's expert that testified. I think they're going to attack that cell phone data. I think they're going to try to suggest that the cell phone data that puts the defendant where everything happened is flawed and that you can't believe it. I have no idea whether or not the defendant is going to testify. Certainly, if he presents likable and believable, he could raise enough doubt. But that is a really dangerous thing to do, and most of the time, defendants do not stand well on cross-examination.
Very quickly, where do you stand thus far after seeing 15 days of this trial?
I think the prosecution did their job, and I think there's one person who did this, and that person is the person who's accused here.
All right. Well, Florina, thank you so much for joining me, and great insight, great analysis as always. We hope to see you soon. That will do it for us here. I'm Michelle Yu, but so much more trial coverage is ahead here on Law and Crime. See you soon.